Thanks everybody for joining us for our industry update this month. Real quick, before we announce our guest speaker for today, I want to let everybody know we are going to host a special industry update next week. That's September 12th at 2 p.m. It's going to be Damian Cox, who's on today, and then also Scott Peterson with CAR. They are going to jump on a special industry update, and we're going to cover frequently asked questions about what is going on currently in our market with regards to forms, the NAR settlement. There's so much confusion out there in the marketplace now that we've kind of shifted over to this new way of doing business, and they are going to address all the questions that they keep getting asked by brokers. So next Thursday, 2 o'clock, join us, tell your fellow brokers, and hopefully that'll be a helpful update as well. And rolling into our wonderful guest today, Pete Muccio has been a repeat guest for 3 or 4 years now with our industry updates. We're so thankful for his time and sharing his expertise. Pete is an attorney who specializes in landlord tenant law. And for any of you who are involved in that in some respect, you know that that is an ever-changing, ever-evolving realm of real estate. So Pete is here today to give us an update on changes that have occurred and what we need to be aware of. So thanks again, Pete, for being on, and I will turn everything over to you.
All right, thanks, Jill. Damian, appreciate the opportunity to be here. Good to see you both. And yeah, let's just dive right in. So I think kind of format here, I'm going to kind of give a little bit of a snapshot, kind of an overview, talk about that ever-changing legal landscape and that major shift that we experienced last year, and kind of go through that snapshot, maybe then focus in on a few specific issues, and we can kind of have a dialogue on some of those, and I think we'll fill the hour. So there was just to give you an idea on how broad the scope was of last year's legislative history. There were more proposed bills in 2024 impacting property management than gun control. And gun control is a fairly controversial topic. I don't know if you realize that property management is as controversial or more in the eyes of the legislature, but yeah, there's a lot of changes that went into effect here, and so the goal is to really just give you some of the highlights, so things that you can be aware of. If you're a property owner, if you're a property manager, and of course, with all laws, there can be various interpretations of things and operational changes. So those are always best discussed with your own legal counsel, right? This is not legal advice to you, but I think you should be aware of these things and discuss what's going to work best for yourself with your own legal counsel. So one of the best examples, I think, of the imbalance that this past session has brought is reflected in 2 different bills that came out of the House, and they serve different purposes, but they ultimately make it more expensive for housing providers and less expensive for tenants to litigate cases and disputes in court. One of those bills was HB 24-1099. And what that's going to do is it's going to eliminate filing fees for tenants in eviction proceedings. So that bill was proposed. The fact that it was even proposed was kind of a surprise, because for years, there has been a mechanism for tenants that were eligible to get their fees waived, to be able to have those waived, based on their income and, how that was relative to other people's income. And we've heard that tenant advocates, a lot of them voiced their support of this bill, in part because the advocates did find it burdensome and challenging to help tenants get information in order to qualify and to complete those waivers and to go through that process. So starting in November of this year, it does not matter if your tenant qualifies for a waiver or makes a 6-figure, 7-figure income. All tenants don't have to pay a filing fee. So contrast that with the impact of HB 24-1286, the Equal Justice Fund Authority, which imposes a fee starting in 2025 on all county court cases of an additional $10 a case in order to assist funding with programs to promote legal access for legal advice to low-income individuals. So the end result is that the cost of litigation becomes more expensive for housing providers facing a delinquent tenant, and less expensive, and more resources become dedicated to those tenants that are in breach or alleged to have been in breach of their lease agreement. So I think that picture, and again, two very different bills that were proposed, but I think that really is a good reflection of what the challenges were this year, and the uphill battle that people were really facing. A lot of this session really kind of felt like a little bit of a deja vu from 2023, right? I mean, there's things that bills that we were seeing that we've already seen before, right? Just cause evictions, or a right of refusal or first offer being run again. Although it wasn't a complete deja vu, because these bills were tweaked, a little different, and a little different outcome. So these bills did not make it into law last year, but this year they did. Both of them passed. The right of first refusal, it's a long bill. I'm not going to get into a lot of that, but it now basically gives local governments the right to make an offer on affordable multifamily properties, which the impact of that on markets remains to be seen.
I will say real quick on that, Pete, I will say that I got contacted by a couple of attorneys that's saying that apparently the commercial brokers don't realize that that law impacts the properties they're selling. So if you are a commercial broker, that went into effect in August, and it does impact pretty much anything that's multifamily. And you really should be telling those sellers to go talk to their lawyers and make sure they understand the full implications of what they have to do for that first right of offer and the first right of refusal.
That is a very good point, Damian. So a bill that does impact, I'm sure there's some property owners and property managers they're tuning in here, and one bill that has just had a massive operational impact is HB 24-1098. And that bill was really designed in the eyes of the proponents to address problems that they saw with tenants being terminated from their leases in a discriminatory manner. Now, this is despite the fact that there are already protections other than this law that existed that prohibit landlords from engaging in discriminatory actions. But the sponsors made it clear that they thought that this was a necessary step for Colorado and for the housing industry. So what this law does, though, is it really creates a much more complicated process for dealing with lease defaults, and it makes the eviction process more complicated than it has ever been in the state of Colorado. In fact, I was just talking with some folks that have a connection to California, and they said that they thought that things were more challenging in Colorado than California, which is really saying something, because
unheard of. Nobody's ever said that before.
Yeah. I mean, so this 1098, I mean, it changes the ability to non-renew a tenant. And, that non-renewal process varies depending upon how long the tenant has been a tenant. So you've got this 12-month marker that's really a critical sort of line, because if the tenant has been at the property and their lease is less than 12 months, then the rules for engagement are different. But if it's outside of 12 months, you can only terminate on a non-renewal basis for cause. So some of those causes can really vary, and might not necessarily be applicable if you're dealing with like a multifamily property. Some of those causes could be if you're moving back into the property, or if you're going to sell the property potentially, or if you're going to demolish the property, or a renovation that is significant could allow for the termination. And I'll tell you what's not significant. A coat of paint is not going to be a significant renovation, right? People say, well, is that defined? What that significant renovation is going to be? No, it's not really defined. And so that creates some ambiguity And what's the problem with ambiguity? Who's the one type of person that really likes ambiguity? Damian, you like ambiguity. Yeah.
You betcha. It's job
Yeah.
security.
It is. It is. Attorneys love ambiguity, right? Because it's room to make arguments. There's a cause that you could terminate somebody's lease for being late, right? But it's late 3 times or more. But is it late? It's not just a regular late payment. It's got to be a 1098 late payment. And when I say a 1098 late payment, I mean they have a separate definition for when something's late. The short version of it is you have somebody that's curing a non-payment situation after they've been served with a demand, after that demand has expired. Okay, that's very different than somebody being late based on the terms of their lease agreement and paying late when their rent was due on the 1st and they're paying on the 10th. That wouldn't qualify as enough of a late payment.
Which means landlords are going to be forced to give notices every time they're late just to try and preserve those rights.
Notices for being late, notices for compliance. I think the idea of somebody giving somebody a courtesy warning of like, hey, you've been too loud, I think those days are gone. And the unfortunate consequence of this is the nature of the impact that has on the landlord-tenant relationship, right? Because if every single violation, you've got to be concerned like, hey, is this going to be a pattern? I might need to give a notice here to this person because this might become a reoccurring problem. And I might have limited ability to deal with a non-renewal situation in the future. And, you're not just talking about the impact on the landlord or the tenant, but maybe the impact on the neighbors, right? Whether those neighbors are other tenants, if you've got a multifamily situation, or other owners, maybe it's a condo situation and you're dealing with that. There's just a lot that kind of flows from the consequences of these really drastic changes. And yeah, I mean, I think you could potentially give a non-renewal if you've given somebody a reasonable renewal offer and they refuse to sign it. But again, Damian, is there a definition of a reasonable renewal offer?
Oh, sure. It's whatever a judge thinks is reasonable.
That you nailed it, right? And so, there's room for argument and everything's going to be a little bit different, right? Like it's going to be the context. It's going to be, how do you frame this issue? If you've got a situation where you've got a tenant that's been in a property or below market for 5 years, and you're offering a renewal at a rate that's more in line with what's the market now, chances are that's going to be a pretty big jump up in rent. But you might have a story to say that, hey, look, that's reasonable based on what the market says, right? That's my explanation. But what if somebody says, hey, you know what, this percentage increase is a really large percentage increase from what they were paying before. Is that reasonable? Depends on how you frame the issue and depends on how you look at that argument, right? So you can see where there's going to be some future disputes related to some of these things.
Or landlords raising it up because they're trying to encourage the tenant to go elsewhere and then they can't rent it for what they offered. You can see where that comes back and bites them.
Yep, that could become an issue too. And when you think about these things that make it more expensive for landlords, what happens when things get more expensive for landlords? What happens to the rates of rent? Rates of rent
they go down, Pete, because landlords are in it for charity.
Right.
Sorry,
No, it's perfect. It's perfect. Yeah. So of course, it goes the other way. So when it goes the other way, well, what's the solution there? What's the solution that we're going to end up running into with the legislature next year?
Well, they're already talking about rent caps and those kind of things of controlling rent in some form or fashion. I mean, we're seeing that nationally even.
Yeah. So it's future battles that will probably be in store. But let's talk about the now, right? So what else? This 1098, big changes related to dealing with the termination, right? So talking about the eviction notices. So an eviction notice is the beginning of the eviction process, right? You're saying, hey, look, you've defaulted on something, and we're giving you a notice related to that. Well, so the notices now have to be served in the primary language of the tenant. If you don't know what that is, the default's going to be English. But that's a big change, right? Because there's a lot of different languages that are spoken in the state of Colorado. And, you know, how many languages does the state have available on their state form on their website? You know, I don't know that they have many. I think they have one. Yeah.
And so, I mean, they even made adjustments for the Colorado Foreclosure Protection Act to say that you just have to have one warning in the person's primary language in order to deal with the language barrier issues that they have. So that, yeah, it'll be interesting to see what comes of this.
Yeah. Well, so you've got to get the right form, right, in the first place, right? So if you've got to deal with the language issue, then it also has changed in how the notice is served. So the previous 20 some odd years, if you were giving somebody a notice, you would either hand deliver the notice to somebody, right? If you knocked on the door, you'd hand deliver it to them. That's personal service. Or if you knocked and they weren't there, you could post the notice. Well, now those two options are still available, but you have to make two different attempts at personal service before you can post. So if you are dealing with a property that is 10 miles away, 15 miles away, you're going to have to drive there. You're going to have to go. You're going to have to try to get it served on day one. And if you don't get it served on day one personally, then you're going to have to go back a second day and try to get that served personally. If you don't get it served personally that day, then you're eligible to post the demand. Okay, so that's a big change. So that's an operational issue that impacts all people that are managing property, whether it's your own property or you're managing for somebody else. So you're having to invest more time in trying to get these things served. The other piece with that too is the dates on a demand have changed. And so you still have to get the timing correct for the date that you serve the demand. Now, when you're preparing a demand, do you know how you're going to be able to serve the demand? No, you don't. You don't know if the tenant's going to be home when you try to serve it. You don't know if you're going to be posting it. So you have to base your date on serving it, assuming that you're going to post it. And so you're going to have to give yourself some time. So you're going to have to plan out that, hey, if I don't get them on this date, I'm going to go the next date, and make sure that you get your calculation correct for the number of days that's necessary. And it's not always the same number of days. It depends on what type of notice you're serving. It depends on the type of property you have and the type of tenancy. So you could have something that's called a CARES covered property. And for those of you that might not remember, the CARES Act goes back to COVID 2020. And there were some protections that were in that act related to termination of a tenancy. Last year, the Colorado Supreme Court held that those provisions of that act that relate to the termination of a tenancy still apply. And so that means that if you're dealing with a covered property, such as a property that has a federally backed mortgage or a tenant that's on Section 8, that particular tenant is a covered property. And if you're talking about a non-payment situation, they're going to get 30 days to cure on that demand. So if you're talking about a 10-day demand or a 30-day demand, you're going to want to build in some extra buffer time for dealing with this service because you don't want to short yourself. If you short yourself on your demand when you're serving your demand and your demand expires, your demand's no good. You have to start over again. So you just delay the process by another month or another 2 weeks, depending on how much time you're talking about. Huge impacts that people need to be aware of, so that you want to make sure, hey, if you're managing your property yourself, your own property, you need to be aware of these. But if you're working with a professional property manager, you want to make sure that they're aware of these things. And I think it's another incentive for people to use a professional property manager who's maybe been keeping up to speed on all of these things. I think it's always been a difficult area to dabble in property management. And I think it's, with all the changes in the law, that's just made it even that much more complicated.
Pete, we had a few questions roll in. Is it okay if I?
Sure.
Okay. Irene is asking if there's some kind of source where they can view sort of a compilation of these bullet points of just new rules and legalities. Is there a good resource for that?
The digest on the legislative page isn't bad, but you have another, Pete?
Yeah, you certainly can look at that. If you look at our website, which is www.tshslawfirm.com, we do have a list that's publicly available of the legislation. So if you want to browse through and take a look at any of the additional legislation, it's got each of those has a history, and you can link directly to the legislative page and download that specific legislation to take a look at. So that's a good resource.
That's great. Yeah, their website is amazing. It's a great resource for sure.
That's much better than the digest.
Does the just cause renewal apply to a lease less than 12 months?
So yeah, so the 12 months, if it's less than 12 months, you don't have to go through these just cause hoops, right? You could still non-renew somebody in the same manner. You could say, hey, look, it's not working out. We need to go. Now, you still can't have a discriminatory reason for terminating somebody. Okay, that's still illegal, right? But you don't have to have one of these specific just cause bases for terminating. So it's also kind of an incentive for people to consider, hey, look, if you want to have the ability to non-renew somebody, maybe I want to have a lease term on the front end that's less than 12 months, that's 11 and a half months, right? I think there's some benefit to that. And some people ask, they say,
yeah, why? I was just going to go ahead.
Yeah. So why would you want that? Why would you want to non-renew somebody? Well, I think if you have the situation where somebody's being difficult and disruptive, you've got to be able to, if you're going to court based on that disruption, you have to prove that. And depending on the type of community that you're dealing with, are you going to have witnesses that are going to be willing to go to court to testify, to say, hey, yeah, they were having this big party, or boy, there's a lot of fights. There's some very aggressive behavior that was going on. You can imagine that is not the easiest thing to get somebody to volunteer to do. So somebody might say, you know what, we're just going to non-renew this situation. We're 9 months into this lease. We're just going to decide, you know what, we're going to go our separate ways and deal with a non-renewal. If your lease is over 12 months, that's not an option for you. So that's when you might want to have that in play. And I think one of the things that I always like to say, because it's true, is that, my perspective, I'm always seeing the negative sides of these situations, right? People aren't calling me up to say, Pete, hey, things are going great. Everybody's paying rent on time. It's just wonderful. Have a nice day, right? I don't get those phone calls. So it's, I know those situations happen where they work out, things go smoothly and everything like that. That's just not the world that I see. So I'm a little bit jaded on that, but that's where I'm coming from, is seeing, hey, you got to be aware that these things do happen. And, if you haven't run into that problem situation, good for you. But I know some people like to say the one thing that, you're guaranteed that you're going to get into some litigation or some disputes at some point if you're dealing with property management, because it's part of the nature of the industry, and it's only a matter of time.
Pete, one of the things I heard after that bill passed was, well, what do you think of just doing an 11-month lease and then renewing for another 11 months and then renewing for another 11 months? And yeah, I just quickly, you get one crack at that. And then after that, you're on it.
One crack. Once a tenant's been there beyond 12 months, they're locked in. I don't see a way around that, of this sort of constant short-term lease renewal. I don't think that flies.
But you get one bite at the apple of 11 months to see how it works with the tenant, and then you can decide whether you're keeping them or letting them go.
Yep, exactly. And so, the control that you have over dealing with screening and what you can look at. That's already been sort of addressed by the legislature previously. They've already made it more limited as far as what you can look at and how you can screen a tenant. So the challenges that landlords are facing, it's a lot more difficult now, right? Because you don't have as much control to limit who's coming into your property. And so that just makes it a higher risk proposition for dealing with that.
Couple more questions, Pete. Are there any restrictions to rent increases as you renew the lease? She's got a slow paying tenant, so can I just increase the rent?
So you've got to be careful there, right? As far as a rent increase situation, because you could see where there could be a scenario, and I think this is probably specifically addressed in mobile home parks when you're talking about dealing with a termination, because there's a lot of different additional protections in mobile home parks where you can't just force people out with the increase of the rent. And so I think if you're offering a lease with an increased amount of rent, you've got to still be able to justify where that increase comes from, especially if you're dealing with a non-renewal or somebody's refusal to sign a new lease, right? If you're dealing with that, what's that increase justified? If you're doubling the amount of rent, is that because you were under market beforehand, or is that double the amount of the market rent? I think that could be a problem for you.
Kelly had a question. If you have a habitually late paying tenant, is it enough to keep written records of payment dates, or do you have to serve a demand notice each time?
If you're going to be terminating based on the 1098 late situation, you've got to be serving a demand. And so having that documentation that you're serving a demand, that they're curing off the demand, is going to be key. So if you're just noting it down and you're not giving a demand, that's not going to be enough to get to that non-renewal step for the 1098 non-renewal.
Okay, let's grab one more and then we'll let you keep rolling with your content. Sure.
Yeah.
Are there also new specific laws around when renters vacate if they do not return the property as they received it and leave it trashed beyond normal wear and tear? What are some laws and resources landlords' rights around deposits? What's considered normal wear and tear or beyond normal cleaning?
Well, that is a great topic. Not necessarily a new topic here, covering on the new laws, but dealing with security deposits. A great resource on dealing with that is looking at the security deposit law. And so I think that's 3812, 101 and sequence to look at that. But the short version of that is you need to, if you're going to be charging damages, your damages need to be damages beyond normal wear and tear, or you can have contracted for cleaning under the statute as well. But when you're talking about normal wear and tear, there's a couple of things that you have to prove, right? You've got to prove what's the condition of the property at the time that you rented it, right? What's that carpet look like? What's the condition of the walls? Is everything functioning? So a lot of times people have good pictures of the after piece of it, but maybe they might not have so many pictures on the front end. Is there a move-in checklist? Are they establishing, hey, what's the problems with this property? And I know that, that's not always an easy thing to get returned from somebody, but sometimes people are really good about noting down like, hey, well, there's a hole and these blinds are falling apart, or, whatever. But that helps you establish, hey, here's what the condition of the property was, or really it wasn't this bad. There was no gaping hole in the wall from the grand piano that was moved out that happened on move out. That's damage beyond normal wear and tear, right? So again, it's one of those things that's open to interpretation too. What is damage beyond normal wear and tear? And it's an area that's fraught with disputes, and lots of small claims cases end up being fought over what is normal wear and tear and those issues. So nothing really new on that front in this legislative session. But, one of the things that I think is new that I'll talk about, that I think is really one of the big ones too, is dealing with the warranty of habitability, right? So big changes there. Although on some sense, it's very familiar to what was there before, because really the warranty of habitability has applied to all leases for several years now. And the very basic fundamental nature of it is the property has to be habitable. It has to be livable, right? At the time that it's rented and during the time of the tenancy. That has not changed. Okay. What has changed are some of the details surrounding that, and mechanisms related to notice, as far as what notice needs to be provided by a tenant and how they can provide notice. Heads up, it's a lot easier for a tenant to provide notice. And there's also now a duty that's put on landlords. If you have a portal, if you have a tenant portal, you got to update that now. In fact, you should have updated that when this law went into effect, to provide an indication of where communications can be sent related to the warranty of habitability. Starting in 2025, you've got to have lease language in both English and in Spanish, talking about how to communicate information about a warranty of habitability. So that's something that we're encouraging people to include in your leases now. Might as well get it in there so that you're not, waking up in December and being like, yeah, what was that thing I needed to add into my lease agreement? There's something. What was it? Don't forget about that. Right? Might as well just, get that in on the front end.
While you're talking about that, a couple things, because this has come up. I think there's a question right now too about, demand letters that satisfy 1098. I mean, I'll tell you guys, my suggestion, just so you know, Pete is Jill and my personal lawyer when it comes to our landlord tenant stuff, just because we have some rentals and we have him handle all that. My suggestion is to just go buy that from your attorney, get your notices, get your leases, get all that stuff taken care of through them. And you guys do sell, do you have the leases updated yet? I know that sometimes it takes a while to get them done, but.
Yeah, we do. We have the leases that we sell updated, and some people have leases that they've been working with for years and that are going through sort of the review process. That's a longer process. But if you're like, hey, I need a lease that complies with these new laws, we have that.
And do you also, I assume, provide the demand notices or those kind of things so that people have the right forms for when they're trying to establish a non-renewal issue if somebody's been late?
We do have that as well. So, one of the things that's changed over the years is we don't have all of the notices available for everybody on our website. It used to be that was the case. We have some, but some notices really, you need to know what you're doing to get the notice correct. And so we've got those that are available, but they're for clients only. That's, if you find yourself in the position of having to deal with that situation, then we do help people out with that.
Yeah, or contact, if you have another lawyer, contact your landlord tenant lawyer and they can provide those. But it's not as simple as a template like it used to be. I remember the Bar Association used to have template landlord tenant forms all the time, and frankly I wouldn't trust any of them if they still have them, because it's changed so much in the last 2 years. So do talk to legal counsel that's versed in this area, guys, and that's not me. So talk to Pete or somebody else and make sure that you're getting the good advice as to how to deal with this so that you don't end up delaying your process because you didn't do it correctly.
Pete, what's the best way for people to reach out to you or your law firm?
So if they go to the website, we do have like an intake process that they can go through and fill out a form to kind of go through that. If they call, if they don't want to kind of go through that, they'll still probably be routed through that process so that we can get people in the queue to make sure that they can sign up. So, but if they're comfortable using the web, that's a good way to get started. If not, then they can always give us a call and we can kind of help walk them through that process.
Yeah.
While you're on the talk about portal, there was a question I think is timely, so I'm just going to ask it. Sure. Regarding tenant portal, is it good enough that the property manager handle that, or does it need to be the actual landlord?
If you've got a professional property manager and they've handled that, you should be on the right track. So they're the ones that are, kind of that front interface for you, and so that's good. I really, I don't know how somebody goes about managing their own property without either having a law degree or having a professional, property manager now. It's a lot of work to try to keep up with all of these things. So, yeah, it's challenging.
Okay,
But
go on with the warranty habitability. Share some more
oh
of your
yeah,
views, Pete.
oh yeah. Okay. Well, okay. So the prior version was pretty restrictive on how notice could be provided, and in fact there was a Colorado, I believe it went up on appeal in a case that really said, hey, look, these are very technical requirements as far as the notice that have to be followed in order to become eligible on that. Well, now it's basically the new law has kind of blown that up, right? So yes, there can be channels as far as, hey, directing communication, but somebody could call up and say, hey, I've got a warranty of habitability issue. They could send a text if they're texting. They could tell your maintenance person that goes into the property, hey, is that mold over there? Do I need to have that looked at? Can that be an issue? All of those things can be triggers. And so it's really important to be aware that it could come from a government, right? Somebody calls out a zoning or a code enforcement and they say, hey, yeah, you need to get this fixed. Boom, there's your notice, right? That you have an issue that needs to be dealt with. And why is that important? It's important because it starts the timelines for when you need to get things addressed. And if you don't get things addressed within those timelines, or if you don't begin to do that work, then the presumption is going to be that you're violating the warranty of habitability, right? So it really puts the pressure on you. And once you become aware of an issue that is critical, you've got to respond in 24 hours of letting the tenant know, maybe advising them of their rights under the warranty of habitability too, and giving them notice of that. And then the clock is different depending on the nature of the repair, right? So if it's a life, health, or safety issue, then it's a 7 days. If it's not one of those issues, but something that's, hey, this is important, falls under the law, then it's 14 days to remediate that. That's quick. That's a quick turnaround. How easy is it to get somebody out to a property, right, to deal with a repair and to address something? Again, this is where a professional property management company comes in, because if you're dealing with somebody that's dealing with many homes, they probably are going to have a relationship with a vendor, right? Where if they call up that vendor and they say, hey, Bob, I'm going to need you to get out to property ABC on 123 Main Street and get this taken care of. Maybe they're going to get a faster response than somebody else calling up out of the blue, cold call. Are they really going to be as responsive? So, yeah, it's kind of a big deal. Another thing, I mean, it's kind of a cool issue. Air conditioning, right, is now part of. Sorry, I had to. Right, it's just it's too like
nice. It's a cool
too,
issue. You're right, Pete. There you go.
Yeah. So it now does clearly fall under the protections of the warranty of habitability. So if it exists in the home, it has to be maintained and repaired. If it doesn't exist in the home, the tenant might have some rights to install that. To ask for that to be installed or to install it themselves. There's a whole process of dealing with that, and there's some limitations. Some homes might not have the capacity, might not be safe for air conditioning to be installed. So just something to be aware of, that is an issue. But I think there's probably been some misunderstanding that I've heard. People are like, well, is air conditioning required now? Do I have to have air conditioning in a rental? It doesn't say that, okay? But it deals with the possibility of adding that, or if it is existing, maintaining that as one of those things. The piece that has gotten a lot more complicated for people with this too is alternative housing. Okay, if it's more complicated and it's potentially more expensive. So the alternative housing piece now requires that if there's a life, health, or safety issue, and you're going to have to put somebody up in alternative housing, either another unit or a hotel, that other unit or hotel has to have the same number of beds that the tenant has in their unit. Okay, so it's not bedrooms, it's same number of beds. Okay, so I think that's kind of an important distinction, because you could be talking about any number of people here, regardless of the bedrooms, right? The hotel also needs to be located near the property, so within 5 miles. And if the stay is more than 48 hours, there's got to be a stove or a cooktop and a refrigerator with a freezer. And if that can't be provided within 5 miles, landlord could go up to 10 miles. Okay. And there could be also the possibility of, if you don't have the cooktop and the fridge, well, then the landlord needs to provide a per diem up front to the tenant. Okay, so let's break that down for a little bit here. So the per diem, what's the mechanism that people have in place now for paying money to their tenants? It's the other way around, right? Isn't the tenant typically paying money to the landlord? So I think there's one challenge right there, just on the front end. So you're thinking about dealing with, the unfortunate situation of dealing with this. You can't just say, oh, tenant, you've got, some renter's insurance. You go to the renter's insurance to deal with this. Tenant says, hey, you know what? This is your responsibility here. Tenant's right. It's on the landlord to deal with that up front. They don't want to put it through their the tenant's insurance. They don't have to. You look at different areas of the state of Colorado. We're a massive state, right? I've lived here for over 20 years. I haven't seen the entire state. There are parts of the state that I'd love to visit, haven't gone to yet. But I know that there are parts of the state where there aren't going to be a whole lot of hotels that meet this criteria within 5 miles, within 10 miles. There's maybe certain parts of the state, the mountains, where, you could go 5 miles, 10 miles, 15 miles. It's still going to be very difficult because there's very limited housing available because of either tourists or just there's not housing available. There's no hotels. So you could see where there's really kind of this focus on this, on maybe the metropolitan areas, and there's no carve out. There's no excuse carve out for dealing with the other side of it. So it's frustrating, right? I think that's just one of those frustrating aspects of this new law. I think the other thing to keep in mind too is that the law has a different timelines for record keeping when it comes to issues related to the warranty of habitability. It's during the tenant's tenancy plus 3 years. So that's different than the requirements for a real estate broker, right? Because a real estate broker, you have to keep records for 4 years. And, it's probably just been a good practice anyway to keep records for maybe as long as 7 years, just for tax purposes, right? And for record keeping, if there's disputes that might pop up, in the future, because disputes can pop up years later after a tenancy. So it's just kind of another thing to be aware of. But yeah, so I mean that's kind of the big things in a snapshot. I didn't even talk about all of the laws, right? I mean, there's still other things that are out there too, but I mean, it's just those are some of the big ones that really hit hard on the property management side of things.
Yeah, just out of curiosity, Peter, you starting to see some of the fallout from the 2023 laws as far as impacts on landlords as well as the court system?
Yeah. It's I think the tough part is that people were starting to adapt to the new laws from 2023 and getting used to their new systems. I mean, these are big operational changes for people to make, right? And the more properties that are involved, or the bigger the company, it's harder to change. So I think there was a lot of that was going on. The new laws, especially the courts, you're seeing it as far as dealing with the virtual appearances piece. And you say, well, wait a minute, didn't everybody deal with virtual appearances during COVID and after COVID? Yes, but then there's other mechanisms now that are in place where tenants can require that the court allow a virtual appearance. So that's been a challenge for the courts to navigate, just on the logistics, because courts might have multiple hearings set. Some of them might be in person, some of them might be virtual, and it's very different being in person in a courthouse, the pressure of being there on everybody, right? I mean, nobody really wants to be there. So there's this motivation to try to come up with some sort of resolution. And, not all cases get resolved. Some cases have to go to trial. I think some of that gets lost in the virtual. And I think that's too bad because I think most cases should get figured out and should come up with a compromise. So I think that's been, kind of one of these challenging side effects, from those laws, for sure.
Oh, that's interesting.
Yeah.
I think we have several questions here too, Pete, if you don't mind indulging us for a minute. Go ahead, honey.
Sure.
Okay, so on wear and tear, if a tenant was in the unit for a few years and it was previously freshly painted, but then upon move out, it had to be fully repainted again at a cost of $3,000. Can I get by charging her a percentage of the paint job, such as 30%?
I'm going to quote an Oasis album cover. It definitely maybe is the answer there, because it's going to depend on the documentation for one, depend on the judge for another, because some judges look at it like, hey, the tenant was there for a year, you're going to have to repaint. If you're talking about $3,000 paint job, that sounds like a fairly extensive situation. And what's the documentation that was really required? There's different levels of damage, right? And how is it really holding up? Is it like a minor little thing, or are we talking about like spaghetti stains on the walls? And I'm pulling that from a real live example. So it's like, how extreme is it that it really needs to be, and how does that get conveyed? Like, is somebody going to be able to look at it and they say, oh yeah, that's bad. That's not right. That's not your normal wear and tear to be able to justify that.
Okay, Joan's asking, do you need to have leases in English and Spanish, even if you only have one property that you rent out?
So there's no requirement right now for a conventional property to have language lease in another language. There's the requirement going into 2025 that you're going to have that section dealing with the warranty of habitability in English and in Spanish. But right now, that's not a requirement yet.
But that section has to be for all leases, not just
all leases.
Doesn't matter if you only have one unit.
Correct. Yep.
Okay, Ashley has a scenario here. She hired a contractor to remove and rebuild dangerous outdoor stairs. The company took the stairs down and didn't rebuild, ran off with the money, and didn't pull demo permits. She had another company close off the upper deck railing for safety, and it currently meets code, but no permit was pulled for the demo, and backtracking that is impossible. Does this affect warranty of habitability?
Yeah, it sounds like that could be a real problem. And, you've got to be very careful about renting out a property with an active condition that could be dangerous, right? So certainly sounds like a difficult situation to deal with and to navigate from a cost perspective, but it could get a lot more costly if you get somebody in there and they get hurt. So definitely going to want to get that figured out.
I thought I read that to say that they did rail it off. They just didn't put the stairs back in. So does that still make it dangerous? I guess that could be an egress, huh?
Man, that could be a problem. Yeah.
Okay.
Yeah. I mean, I think scenarios where you've got sort of a hazardous condition, but it's like marked off, where you're like saying, hey, don't use that exit, don't use that deck. There's this disclosure aspect of it that gives you some help, but you're risking a lot, I think, otherwise. So it's especially in the litigious nature of the world today, it's I guess you got to decide what's right for you as far as how much risk you want to take on. But I'd be very conservative about that and suggest that you'd want to get that fixed first before you rent it out.
On the same subject of warranty of habitability, Stacy's asking, so with quote, broken appliances now falling into that coverage, does a tenant have grounds to complain about the efficiency of the appliances, claiming they're not working properly?
You know, that's a really good question, because I think it's like, well, what degree? And I'm thinking dishwashers here, right? Because there's a range in dishwashers where you've got, you know, a high-end dishwasher that's really going to like just do some amazing stuff, and then you've got maybe a basic dishwasher that it's going to move some water around and maybe not get, you know, that spot-free finish that you're really talking about. And you know, we're not at the point yet where the law dictates that, you know, hey, it's got to be this like peak primo product, right? They're not dictating that it's got to be a Viking oven in your kit in every kitchen. But I think there's a real question of fact of, is it working, or is it, you know, just not good enough type of thing. And the law doesn't require that we have granite countertops, that we have all these high-end finishes. It requires that it has to be habitable and these appliances have to be functioning. So it becomes a question of fact of, is it functioning or is it not? And then when you're faced with that issue, you know, you have to look at, like everything, what's the cost of being right? You know, is the cost of saying, hey, yeah, that works. Is a judge going to agree that that works well enough to cook, clean, you know, whatever, keep the fridge, keep stuff cool? You know, when you're talking about a refrigerator, I think that's kind of a big area. You know, is it going to, you know, maintain a safe food temperature, right?
Okay, what about homes without ductwork? Is an evaporative cooler no longer acceptable?
You
I
know,
think that was going back to the question on your AC, your cooler
Yeah.
yeah,
topic.
yeah, the cooler topic. Yeah, so you know, evaporative cooler can work, right? That can be okay as a cooling device. And you know, the law does talk about adding cooling devices and doesn't necessarily dictate that it has to be an air conditioning unit. So an evaporative cooler could work out okay.
Can you go over the newer rules regarding vetting tenants?
That
Um,
sounds like that might not you may not be able to get through that in this 3 minutes that
yeah,
we have.
yeah, no, I don't have time to do that. But I would say that, look, it's um basically you're limited in your lookbacks on both criminal and credit. Okay, as far as the time period, it's no longer an unlimited look back, so you're time limited on those things. And it also can vary depending on how somebody's coming to you. Somebody's coming to you with a Section 8 voucher, you're not going to be able to run their credit. Those are
And
just
reality
two
is
very short issues.
if you're a landlord, you should be looking into a lot of this stuff right now because there's been so many changes in the last several years. Property managers, they have classes out there for them going over the changes and things that have happened in the last several years. If you're a landlord, even if you're not doing property management, it may be worth looking at those classes, guys, just to get caught up on what's changed and make sure that you understand what's going on for your own personal business as a landlord.
Yep.
Is a mandatory carpet cleaning fee in a lease acceptable?
Could be. It could be. It could be
Maybe,
considered. Maybe. Yeah. Maybe.
Definitely maybe.
Contracted. Definitely maybe. You know, it's a decent album. You know, it's and Oasis is getting back together. So hey, revisit it. Right. It's the thing is that, you know, the argument there is that it's contracted for damages, right, and that's supported by the lease. But how that plays out, you know, if it goes to court, there's some degree of uncertainty there with that. And, you know, was the carpet cleaned when they left? Did they clean it professionally? You know, it's very difficult sometimes to say with an absolute broad brush that, hey, everything's going to be one way or the other. You know, we deal with a lot of gray areas and ambiguity. And so, you know, it's you know, the legal answer of it depends or maybe, it's that answer for a reason, because there's a lot of things that could impact these things. And, it would be nice to be able to bring certainty to a lot of questions and to say like, no, this is absolutely how this has to be. But unfortunately, that's not always the case. And so that's just one of the frustrating aspects of practicing law is that there's a lot of ambiguity.
TJ Weiss just put in there at a minimum, get involved in the Colorado Landlord Coalition. So I just put that in the chat for everybody. If you are a landlord, that is definitely a organization that's worth looking at, because they are trying to advocate on behalf of landlords, which obviously need more help. So
absolutely. And I'll give a plug too, when you talk about the laws and all these changes and everything like that, the Colorado Landlord Legislative Coalition was definitely a key voice down at the Capitol and reaching out and talking to legislators and getting landlords' voices heard. So, you look at some of the moderation and some of the positive impacts. They were a key player. It's a newer organization, but they're really out there pushing for landlords. So.
And I also put another resource in there for Mark Cunningham that's on September 11th. That's free from CAR for some property management advice for you guys too. So go ahead, honey. You have more?
Yeah. Do you have time, Pete, for a couple more questions?
Yeah, just a couple more minutes and then I gotta up on
jet to your 3 o'clock because it's 3:01. Okay, in case of capital improvement construction done by an HOA that requires tenants to move out from a condo for 2 to 3 weeks, who's responsible for paying tenants temporary housing?
Well, I think you're probably going to be on the hook there as the landlord. You might have to look to the HOA for that, but the tenant doesn't have the contract with the HOA. They have the contract with you. So.
Okay, and is there a cap on charging extra rent for roommates that move in later on the lease, or any laws with charging a roommate rent?
Well, that's interesting. You got to be careful with the charging extra rent because you're limited on rent increases once per year. There's not really a specific amount that says, hey, like here's a cap on what you could charge when you've got more people that are coming into the property. I guess it's what the market bears.
Okay, and question, when is a good time to update my lease agreement?
After the legislative session has ended is typically a good time to look at getting that taken care of.
And so for after this so now is what you're saying, Pete, is now is a good time to update your leases and get everything updated and make sure that you understand some of these changes.
Yep.
All right, Pete, we'll let you get on with your day. Thank you so much for your time. You're just a brilliant speaker, and we really appreciate your time. This is always an incredibly helpful update. So thank you so much for joining us today. We appreciate you.
Thank you, Jill, Damian. Good to see you both, and thanks for the opportunity. Stay safe out there.
All right, see you guys.
Right. Thanks for joining, everyone. We'll see you next Thursday.